The envelope was not delivered by a process server. It arrived in a locked diplomatic pouch, marked for the attention of M. Rachel Meghan, the Duchess of Sussex, its provenance from the Central Office of the High Court of Justice in London. Its journey had been tracked, logged, and secured by agents of the Crown. Inside, beneath the formal letterhead, was a single line of text that made the $14 million Montecito mansion feel as fragile as a house of cards in an earthquake. You are hereby commanded to attend as a witness in the matter of to Frey v. the Duke of York. A subpoena, not a request from a tabloid, not a palace suggestion. A legally enforceable court order, signed by a high court judge, demanding her testimony under oath about her relationship with Prince Andrew. In London, at that precise moment, the doors to the 1844 room at Buckingham Palace were closed and secured from the outside by 2 household cavalry officers. Inside, a gathering was taking place that had no precedent in modern royal history. It was not a family meeting. It was a legal war council. Seated around the antique table, under the gilded gaze of forgotten monarchs and oil paintings, were the 5 most powerful lawyers in the United Kingdom. Sir James Eadie, the Treasury Devil, the government's top barrister. Fiona Shackleton, the legendary Steel Magnolia family lawyer who had represented King Charles. David Panic, the constitutional law titan. Alongside them, 2 new grim-faced additions, a senior partner from the firm representing Prince Andrew's victims in their ongoing civil suits, and a liaison from the FBI's International Corruption Unit. The king was not present. His absence was a message in itself. This was beyond family. This was about the survival of the institution. Sir James opened a thin, red-bound file. The situation is no longer reputational. It is jurisdictional and existential. The American plaintiff's legal team, emboldened by the leaked materials, has successfully petitioned the court to expand the scope of discovery. They are no longer seeking evidence solely against the Duke of York. They are now building a case for criminal conspiracy to traffic minors and racketeering within his social circle. He let the words racketeering hang in the heavy air. It was an American legal term, brutal and expansive, capable of ensnaring anyone who had knowingly benefited from or facilitated the criminal enterprise. The subpoena for the Duchess, Shackleton continued, her voice like cut glass, is the first move. They will ask her to confirm the authenticity of the tapes, the letters, the driver logs. They will ask her to detail the nature of her relationship with the Duke of York between 2011 and 2015. They will ask her about Jeffrey Epstein, about Ghislaine Maxwell, about yacht weeks and recruitment parties. Most damagingly, they will ask her to identify other individuals present. The FBI liaison leaned forward. Our interest is in the pattern. A witness of her profile, even a peripheral one, provides a roadmap. Her testimony, under penalty of perjury, could be the thread that unravels a much larger tapestry. It could force depositions from other high-profile names in those circles, names that have, until now, been shielded by wealth and jurisdiction. In Montecito, Meghan stared at the document. Her lawyers, 3 of them on a panicked conference call, were talking over each other. We can fight it, claim it's harassment. That you have no relevant information, fighting it looks like obstruction. It makes you look guilty of hiding something. If you comply, you walk into a perjury trap. Every vague answer from your past interviews becomes a perjury charge if you contradict it under oath. She wasn't hearing them. She was hearing the voice of her now estranged husband, Harry, from their last shattered conversation a month prior. They will come for you with the law, Meghan, not the press. The law. And when they do, I cannot be next to you. He had seen this coming. The palace had seen this coming. They had cut her loose not just from the family, but from their legal protection. Back in the 1844 room, David Panic delivered the constitutional verdict. The Duchess, while retaining her title, is no longer a working member of the royal family. More critically, she is a U.S. citizen residing on U.S. soil. The sovereign grant does not fund her legal defense. The Crown's legal obligation to her is effectively zero. The room was silent. The meaning was clear. She was on her own. However, Panic continued, her testimony, if given, becomes a matter of the highest national interest. Anything she says under oath becomes a permanent, discoverable record that reflects upon the monarchy. Her words could be used to bring down a prince of the blood, or worse, to implicate the institution itself in a cover-up. Sir James Eadie steepled his fingers. We are not here to save the Duchess. We are here to contain the blast radius. Our objective is singular, to ensure that her testimony, if it cannot be prevented, is managed, mitigated, and sealed to the greatest extent possible. We must negotiate with the plaintiff's lawyers and the U.S. Department of Justice. We must offer them something. Offer them what? Asked the lawyer for Andrew's victims, a keen edge in his voice. Shackleton met his gaze. Cooperation. Not from her, from us. Streamlined access to certain archives. Witness statements from certain staff. A reassessment of the Duke of York's status and security provisions. In exchange, the Duchess's testimony is given in a private, sealed deposition, not in open court. The transcript is never released. It was a trade, a sacrificial offering. They were offering to throw Andrew to the wolves formally and finally to build a firewall between Meghan's testimony and the public, and thus, the crown. And if she refuses to play along? The FBI agent asked. Sir James's reply was ice cold. Then she faces the subpoena alone. She will be deposed in open court. Every sordid detail will be broadcast. And when she is inevitably asked, "Did anyone in the royal family ever advise you to conceal these relationships?" she will have to answer, under oath. And whatever she says, true or false, will burn down everything that is left. The message was drafted within the hour to be delivered through back channels to Meghan's legal team. It was not a lifeline. It was an ultimatum wrapped in a threat. Cooperate with our containment strategy or be destroyed by the legal storm alone. Your choice. The War Council had convened not to rescue a duchess, but to bury the danger she represented. The subpoena in her hand was no longer just a legal document. It was a lit fuse. And in London, the custodians of a 1,000-year-old institution had just decided where to place the blast walls to ensure they survived the explosion, even if she and Andrew were obliterated in the blast. The negotiation did not happen in a law office, but in a bland, soundproofed conference room at the U.S. Embassy in London. The air was thick with the smell of stale coffee and profound mutual distrust. On one side, two of King Charles's most senior private secretaries and Sir James Eadie, the Treasury Devil. On the other, the lead counsel for Virginia Giuffre's Legal Foundation and a deputy assistant attorney general from the U.S. Department of Justice's Human Trafficking Unit. Meghan's own lawyers were notably absent. She was the subject of the deal, not a party to it. Let's be clear about what we all want to avoid. The DOJ official began, her American accent sharp in the room. A media circus of historic proportions. A sitting sovereign's family member embroiled in a public RICO deposition. It's in no one's interest. Sir James nodded. A fractional movement. Our interests align on containment, but we require guarantees. The Duchess's testimony must be given via written interrogatories, followed by a single, closed-door video deposition. No public hearing. The transcript is sealed for 50 years under a mutual national security injunction. The American lawyer for Giuffre, a woman named Elena Cruz, known for her relentless discovery tactics, smiled thinly. You want us to trade a public reckoning for a private chat? That's a big ask. The victims' families want sunlight as a disinfectant. What are you offering that's of equal value to sunlight? One of the king's private secretaries slid a single sheet of paper across the table. It was a list typed, without letterhead. Full, unredacted access to the Duke of York's appointment diaries from 1999 to 2011. The originals. Not the sanitized versions provided previously. Included are annotations, guest lists for private events at Balmoral and Sandringham, and travel manifests for his official overseas tours during that period. Cruz's eyes scanned the document, her expression unmoved. Andrew's diaries are a start, but my client's case is about patterns and networks. A list of names at a shooting party doesn't prove conspiracy. The Duchess's value is in painting the picture inside those circles. She's a social archaeologist. She can tell us who was who, what the understood transactions were. The DOJ official leaned in. We also want something you haven't offered. A formal, on-the-record statement from the royal household, acknowledging a past failure of duty of care and instituting a permanent, independently audited safeguarding protocol for all staff and minor relatives. It's about institutional reform, not just one bad prince. The palace men exchanged a glance. This was the price. They had to admit institutional fault to protect the institution from a worse fate. And in return for this, archaeologist testimony? Sir James pressed. A sealed deposition, Cruz conceded. But on our terms. It's video recorded. We have the right to ask follow-up questions based on her answers for a period of 1 year. And while the public transcript is sealed, a summary of her verified evidence names, dates, connections is provided to law enforcement agencies in 5 countries. The information is used, just not published. It was a brutal compromise. Meghan would be spared the global spectacle of a live cross-examination, but her testimony would become a classified weapon in the hands of prosecutors worldwide. She would be an informant. Back in California, Meghan listened to the terms via her lawyer, her face pale. So, I provide them a map. I name names. I become the one who turned on that entire world. And in return, I get to not be humiliated on CNN? In return, her lawyer said carefully, you avoid a public perjury trap. You potentially avoid being named as a co-conspirator in a RICO case yourself. And you create a scenario where the palace has a vested interest in you not facing further legal action. They get their containment. You get a shield, albeit one made of their self-interest. And Harry, the question was a whisper. Prince Harry's position, through his solicitors, is that this is a matter for you and your legal team. He has formally recused himself. His focus is the children. The word recused was a legal bullet to the heart. He had legally detached himself. She was alone in the negotiation, with 2 mighty powers. The Crown and the U.S. justice system, bartering over her voice, her memory, her past. In London, the deal was struck in principle. The palace would throw Andrew's legacy to the wolves and accept a historic, humiliating admission of institutional failure. In exchange, Meghan's testimony would be weaponized, but discreetly. Her value was no longer as a duchess, nor even as a witness, but as a high-value intelligence asset in a global prosecution. The final chilling clause was delivered to Meghan's team. The Duchess will begin preparatory sessions with a joint US-UK legal team to review all evidence, the tapes, letters, logs, photographs. She will be coached not on what to say, but on the precision with which she must say it. Any deviation from verifiable fact, any attempt to memory hole, will be considered a breach of the agreement, resulting in the immediate unsealing of the entire deposition. She was to be prepped like a spy before a debriefing. Her past was to be dissected, catalogued, and formatted for legal utility. The day before her deposition was to begin, a courier delivered a small sealed box to her Montecito home. Inside, with no note, was a simple, cheap microcassette recorder of the kind used in the early 2000s, and a single tape. With trembling hands, she pressed play. It was a clip she hadn't heard before, her own voice, weary, saying, I just need this one last connection, Andy, the royal one, then I'm done. I'm out. A real life. Andrew's laugh, dismissive. You think a real life is better than this? Her voice, firm, definitive, I know it is. The tape ended. It was a recording of her years ago outlining her exit strategy from the very world she was now being forced to meticulously excavate. The irony was a gothic horror. The palace hadn't sent it. Her legal team hadn't. It could only have come from one source, the victim's lawyers, proving they had more, always more, and she was utterly transparent to them. They weren't just asking for her testimony. They were demanding her complete and total surrender. She was to be the royal insider who would bring the whole gilded edifice down, not with a bang on television, but with a whisper in a sealed room that would echo through courtrooms for a generation. The subpoena hadn't just compelled her presence, it had conscripted her into a war, and both sides had now agreed on her role, the ultimate turncoat witness. The deposition was not taken in a courtroom, but in a secure, windowless facility at RAF Northolt, chosen for its status as crown property with extended diplomatic immunity. It was a clinical, sensory deprivation chamber of beige walls and humming ventilation. Meghan Markle sat at a simple table, a glass of water untouched before her. Facing her on a large monitor were the faces of the lawyers, Elena Cruz for the plaintiffs, the DOJ official, and a representative from the UK's Crown Prosecution Service. To her left, her own attorney. To her right, a silent, watchful note-taker from the King's private office. There were no cameras for the public. Only a single high-resolution recording device, its red light at unblinking eye. This was the containment cell. Her words here would never scream from a tabloid headline. They would seep poisonously into the foundations of power. The questioning began not with Andrew, but with architecture. Please describe the social hierarchy of the Soho House membership circle you frequented between 2011 and 2013. Who held the influence? How was access granted? It was a question designed to bypass yes or no answers. It forced her to narrate, to paint the ecosystem. Her voice, initially thin, grew steadier as she moved into the detached language of social analysis. She described gatekeepers, angels, sponsors. She named none of traffickers but of financiers, philanthropists, gallery owners who formed the respectable front row of that world. Each name was a thread. The lawyer's job was to follow each thread to its dark end. And Prince Andrew's role in this hierarchy? Cruz asked. Meghan paused. This was the precipice. He was a nexus, a bridge between the British establishment and that international social circuit, an introducer. An introducer of what, specifically? Of people, she said, her legal training kicking in. He facilitated connections. Connections for what purpose? Social, professional. Did those connections ever involve the provision of young women to older, wealthy men? Objection, her lawyer said. Calls for speculation. Sustained, the DOJ official said, though her expression showed the question had been for the record, not for an answer. They moved through the evidence like surgeons. The tape where she said not one of his girls anymore. Who is his? Jeffrey Epstein, and what did being one of his girls entail? They presented flight log. Is that your signature on the customs form for the St. Thomas trip? They showed photo from Bougie's nightclub. Who took this photograph? What was the mood after it was taken? For 6 hours, she was not Meghan the Duchess. She was a topographer of a hidden kingdom, drawing a map for those who wished to burn it down. She did not admit to crimes. She provided context. She explained the unwritten rules, the currencies of favor and access, the understood pathways. In doing so, she confirmed every terrible implication. At the end, exhausted, came the final question from the king's representative, his first and only interjection. In all your interactions within this milieu, did you at any time believe that the institution of the monarchy, or any of its senior members acting in an official capacity, were aware of or condoned criminal activity? She looked directly at the lens, the full weight of the past year in her gaze. It was the question the palace feared most. The answer was in the carefully crafted statement she had been provided. I had no knowledge of any criminal activity, she recited, the words tasting of ash. And I never witnessed any member of the royal family in any context that suggested such knowledge. It was the necessary lie, the seal on the deal. She had given the plaintiffs their roadmap to the shadows. In return, she gave the crown its blanket of deniability. Her testimony was complete. She had been both weapon and shield. The red light on the recorder blinked off. The containment was successful. The scandal was buried alive in a vault, where it would not breathe public air, but would instead haunt the corridors of power as a silent, official secret. Meghan Markle had not borne witness for justice. She had performed a state-sanctioned exorcism. And in that sterile room, the last vestige of the person she had once pretended to be, the innocent who knew nothing was finally and formally erased.